Welcome to Practically Political. It's great to have you as always. I'm Dave Spencer.
And I'm Carrie Sheffield. Let's get to it. We've got a special guest today, Shermichael Singleton. He's been a longtime friend, and I'm a big fan of him. Very prominent conservative commentator. He's an expert on African-American issues and the Republican Party reaching out. And he worked in the Trump administration for Secretary Ben Carson, who is a personal hero of mine. And Shermichael just has a lot of very thoughtful things to say. And I think he really fits the ethos of Practically Political. Shermichael, welcome.
Hey guys, thanks for having me. It's great to be on with you, Carrie. Great to be on with Dave, who was on my radio show when I first got a SiriusXM radio show. So I'm happy to be on the podcast with you guys.
Great. Well, Shermichael, I've been just curious to get your thoughts on this 14th Amendment argument. I just got in my inbox. I'm on the press list for a number of campaigns from Vivek Ramaswamy's campaign, and he said this is wrong. They shouldn't be doing this. The 14th Amendment was created in response to Confederate appointees.
Yeah, that's correct. So it was ratified past 1868, and they're specifically discussing Section 3, which was to prohibit individuals of the Confederacy who obviously attempted to overthrow the entire government, right, from holding a high elected office. So in that case, it makes perfect sense. I'm not exactly sure that one could draw the parallels to Trump in that regard, but what they're attempting to do is saying that he embedded or abetted insurrection against the United States government. I don't know if there's legal standing for that. I'm not certain if I would necessarily agree with that from a legal argument. And from a political perspective, I would go as far as to say that it does appear from the perspective of many conservative voters as a way to usurp their right to choose who they want to be the nominee of the Republican Party and to usurp their right to vote for who they want to potentially be the next president of the country. And so I think in that regard, with how divided things currently are, I think these attorneys are playing with some political flames here that they may not completely understand. And I have a tremendous amount of respect for lawyers, and I have a tremendous amount of respect for the experts who are part of this. I mean, some of these guys are some of the leading scholars in terms of constitutional law in the country. But I vehemently disagree with the political implications of something like this. And if they were to be successful, not only, I believe, in Colorado, I think New Hampshire, Maine, and several other states are considering such a thing. I just do not think it would be good if the appearance was that they were usurping people's right to choose who they want to vote for. We have to be very careful with these things, considering the current state of the country.
Well, I agree with you, Shermichael, and I agree. There's the two fronts here. There's the legal front, and there was an Obama appointee judge in Florida who dismissed this challenge with the 14th Amendment grounds, saying that there was no standing. So that was a very interesting ruling by, again, an Obama appointee judge. And then there's the fact, as Vivek Ramaswamy pointed out, there's precedence under, it's a case called the Free Enterprise Fund versus Public Company Accounting Oversight Board, where the description in the Constitution, it's called an officer of the United States. It's somebody who is appointed by the president to aid him in his duties under Article 2, Section 2. So if you're an aide and you're appointed by the president, you're not the president. So it actually doesn't even apply to the president legally from a standing point. And then I agree with you, Shermichael, that politically this just smells to high heaven that if it's Trump now, who's to say it wouldn't be a Republican later? It sets a very dangerous precedence, especially if you're a Democrat and you claim that you care about enfranchisement, voting rights, civil rights, that you would deny franchisement to potentially tens of millions of voters. Smells to high heaven. I don't know. What do you think, Dave?
Well, anything Vivek says, I take with a grain of salt. But putting that aside, and let's put aside also for a moment, whether or not there's legal standing here. First of all, I have one question. All these people that are bringing it up, where were you guys a year ago before Trump ran? Or frankly, where were you after January 6th during the second impeachment trial? The time to have brought this up was then. I think it would have had a lot more gravity. I think it would have had a lot more relevance to bring it up then. Now, even though I think I agree that you can make a good argument that he shouldn't be eligible to run, the point is, it's too late. and it's going to do is just damage the process more. Plus, there's going to be lawsuits, and it's going to end up to the Supreme Court. And in defense of the Supreme Court, the closer you get to an election, the less likely a court is to try to interfere with anything that has to do with that election. So I think it's a terrible idea, and I think the timing is off. And like so many things that people have brought up against Trump, it's too little too late. But I think it should have been brought up. Now, getting back to the actual merits of the case, I do think that if you look at what Trump is being sued for in these 4 lawsuits, even though most of us, Kerry, I think, is one of the few, believe that there's no question that Trump incited the insurrection. He was responsible for it. But if you look, that's not what he's being charged for in these cases, right? He's being charged for other things. So again, I think they have a stronger case in other areas like defrauding the American people, racketeering, that type of stuff. So overall, it's too little too late. So sorry you guys weren't here earlier.